All right, well,
Morning, everybody.
so we are here to do a class about contract contingencies in our purchase agreements. The standard ones, and then we'll get into some that may not be part of every transaction, but it allows us to just get a clear understanding of what the contents of the contingencies are, how to know when there's been satisfied, what it means if they don't get satisfied. And I figure the format that we'll use is to just go through a purchase agreement, and then as we get to the normal contingencies, we can discuss it and just make sure everybody's on the same understanding. And that's what Bill is here for, is to make sure we're getting correct information rather than just me giving my opinion.
I break the tie.
So I pulled up both the Livingston County purchase agreement and then the Ann Arbor purchase agreement. They have similar contingencies, but slight differences and in a different order. Since I'm more familiar with Livingston County, that's what we're going to start with, just to give us the order of things. The very first contingency we get to in the Livingston County purchase agreement is the financing contingency. And so, Bill, do you want to explain to us what this language here means, where you have here purchaser further agrees to apply for such mortgage within blank number of days, and then if a loan approval from the lending institution cannot be obtained at no fault of the purchaser within blank days from the date of acceptance of this purchase agreement may be declared null and void by the seller, and deposit shall be returned to the purchaser.
So this is one that we
Come
this way to the light.
Yeah.
How much camera room do I have?
Next to the screens.
Okay.
Stuff, yeah.
So I feel like we very seldom get it to this point about the mortgage. Because typically if a deal's gonna fall, it falls for inspections rather than mortgage approval. So we don't get here very often, but this is enough. So if you have an inspection and the inspection goes through and then the buyer gets cold feet, this is the one he's gonna try to use to get out of the deal. And depending on how friendly he is with his mortgage rep, he may be able to get a denial letter within the time specified in this contingency, which gets him out of the contract. So he may, the inspection may be fine and you may take a side, but this one, if there's enough time built in here. Now, the other thing is sometimes the time that you put in here is really short. Sometimes you say 10 days or whatever, and so the inspection contingency in this one kind of dovetail, and he can get out if he can get a denial letter. Now, of course, it says here cannot be obtained at no fault of the purchaser, and I've seen deals where the purchaser frustrates the intent of that paragraph. The intent of that paragraph is that he's going to cooperate with the lender. So the lender asks him for, tax returns or pay stubs or whatever, and he just doesn't give them to the lender. That's not acting in good faith. And so that default is at his direction, at his fault, because he didn't cooperate. And so therefore he shouldn't, in that circumstance, get his earnest money back. Believing it in your head and proving it in court are two wildly different things. So it's a very difficult thing to prove sometimes that he didn't cooperate with the lender and to get the earnest money back to your seller. And as the case in all of these contingencies, litigation is your way to prevail and prove that the person violated the contingencies. And oftentimes people don't want to spend the money to do that. So I get a lot of people in my office that are mad right? I know that he didn't cooperate with the lender, therefore my seller should get the earnest money back. Oh, okay. But we become an escrow agent when the earnest money comes to us. And we don't really have the ability to be the judge and jury and decide if the purchaser did violate this and it was at his fault that the loan didn't get approved. So, so this contract isn't worth a hill of beans because you're not going to enforce it. Well, it's not our job as realtors to enforce it. It's the seller's job or the buyer's job. Yes, ma'am.
Is there a recommended, what would you recommend for the days?
So, because my practice that I've typically done
Yeah.
is 5 calendar days to start the loan application
Yeah.
process. And I've typically put in there 30, 40, 45 days for the, date from the date of acceptance to get the loan approved.
Right.
Now, what are the risks or benefits to whatever you're putting in?
If you put the longer period you put here, gives the buyer, if he's gonna try to get out, right? It gives him a second bite of the apple, I will call it. Because the inspection period is always short, like a week or 10 days, right? You never give him 30 or 45 days to get his inspection done. So if you give him 45 days here, right, you're giving him a second bite of the apple, but honestly, it depends on the lender you're working with. If you're working with Tanya at Michigan United Mortgage, I mean, she can almost close a deal in 14 days. Forget about mortgage approval. She can get it approved and closed. So if you put 45 days here or 30 days here, you're stretching out the buyer's ability to walk, in my opinion. So I would shorten that up. I would say like 20 days at the most.
But now, if you put 20 days in there, if the 20 days have come and gone and the contingency has not been satisfied where you don't have the clear to close, does that give the seller the ability to declare the contract null and void and cancel the transaction?
Well, to me, this says loan approval, doesn't say clear to close. So, I mean, you can fool around with that language also in court, And the other thing that we're just generally in the realtor community is we're not on top of our dates as a rule. And either we're having a right fight, right? I'm right, you're wrong about the inspection. And it pushes everything back, delays everything, right? And we've never done an extension. So we should be on top of our dates to know if 20 days is gonna come and go. Do an extension of his time for loan approval. You should do an addendum for that. Same thing with inspection. And we don't typically do that.
Yes. For remove the contingency, so if the date already over, like if say 30 days or 5 days already over, but the buyer didn't remove the contingency. If the date over, which automatically already removed.
Well, if the buyer is confident and your seller wants to, you could remove, 20 days is coming up, right? And he says, I'm gonna get loan approval, I'm not worried about it. Remove the contingency, then he bought a house.
If they did it writing,
Right.
but the date already passed, so which means already removed, right?
No.
No?
You have to remove it in writing.
Writing?
If you're gonna remove it, you should remove it in writing.
So
Just let the time expire. Same thing if you're gonna extend it. You shouldn't just let the time expire. You should either extend it in writing or remove it in writing.
I believe actually, because, let's compare it now to the Ann Arbor contract, because I actually think you're correct with the language that appears in the Ann Arbor one. Which is later on in the first screen, this is item number 28, the financing. And so, here we have similar where, you have the blank days
See, this one doesn't talk about approval at all. Right, the Ann Arbor one just says buyer will provide evidence of mortgage at an appraisal order. Within a certain number of days, that's not talking about, then it goes on to say. If such evidence is not provided, the seller may void the contract, buyer to notify seller in writing about mortgage approval. Then you have your time frame. And then it will be deemed waived if he doesn't do that. So that's a little different than the Livingston County one.
The very first blank here, where it's talking about the contract is contingent upon buyer qualifying and obtaining the mortgage commitment within blank number of days of final acceptance. So that would be like the second blank for Livingston County.
Yep,
And so,
but it doesn't say what happened.
yes,
It
that's
does.
right. And that's why,
That's why you have to then go down here. And, this contingency, if he doesn't do it, is deemed waived. So that's a little different than how Livingston County works, but I would always, one of my big complaints is that we come up on the days, right? We come up on 20 days, we come up on 30 days, whatever, and we don't do anything about it. We just let it expire, right? And pretend like it's not there. Until the buyer waves his hands and says, hey, I can't get mortgage approval. Then you're mad, right? And then we enter into the right fight about whether we're gonna release the earnest money or not. And I can tell you, we're not. We're gonna hold it until you guys fight it out about, did he do something wrong or not? Yes,
So how would you write an addendum extending, because you're not extending the contract, you're not extending the closing date.
no, you're just extending the time for mortgage approval. So it's just simple. I'm a big believer in keeping addendums simple. Purchaser and seller agree to extend the time for mortgage approval to, and give a date.
So if you fill the blank within 30 days, but final acceptable with
Right.
the contingency. If past the 30 days, the buyer raises hands, oh, I want to walk away, which means no.
Well, it says
Because
the
already
seller,
passed.
it says the seller may void the contract, doesn't say the seller has to void the contract. And it also says if he, mortgage denial or approval within certain number of days of the acceptance of this contingency will be waived. So if he doesn't get it in that time frame, I would say that this contingency is waived. But the buyer's not gonna feel that way. The buyer's gonna say, I'm still working on it. You know the conversations you have on the phone, right? I'm still working on it. I gotta do this, I gotta do that to get my final approval. You're saying, well, my seller wants the money and I don't wanna give you another extension and we don't believe you, and so that's where the fight over the earnest money happens. Okay, and regardless of the timelines, I mean, we are not going to automatically release the earnest money to either side, no matter what this says. Because unless I get some sort of an agreement in writing to tell me as an escrow agent, and Remax is an escrow agent, once we get the earnest money, if I don't get a mutual release or something that tells me, give the earnest money to the seller or give the earnest money to the buyer, it's gonna sit in our escrow account till we get that. Now, there are some exceptions to that, but that's the general rule.
So my question is, if the buyer didn't decide remove contingency, which is good for the buyer or good for the seller?
Well, I would argue it's good for both.
Good for both?
Well, because your aim should be to get them to the closing table. And so if you remove this contingency about financing, then the buyer is in essence saying, I'm confident that I can get a mortgage. And the seller's like, great, my house is sold, let's schedule a closing. So to me, it's actually good for both.
So which means that the buyer don't have to remove the contingency.
We just have to, no, I mean, we can't hold a gun to anybody's head and make them sign anything, right? But I think when you're running out of time in any of these contingencies, you got one or two options, well, three really. You can just let it expire on its face and pretend it doesn't exist. That to me is a bad option. Option number two is extend it. Right? Option number three is waive it and say that it's not gonna have any effect anymore. So those are really your three options. I don't know that, to me, if everybody's on the same page and everybody's working towards a closing, then waiving it is your best, waiving it or extending it are your best two options. And that doesn't hurt anybody. I've seen, I've been in court with a judge, right? Arguing about this very paragraph, right? And I want to give the earnest money to the seller. And the buyer is claiming it. And the judge said to the seller, did you work with the buyer past this date as if you were going to close? And the seller said, well, yeah. And the judge said, well, then you extended this by your actions.
By default.
By default. And so they didn't give the earnest money to the seller because the buyer was still saying, I can get mortgage approval, I just need more time. And the judge said, well, then you got more time because the seller by their actions extended it. They sent emails and said, oh, I guess it's okay. But nobody did anything in writing. That's why we were in front of a judge. But the judge said, by your actions, you have extended the contingency. So,
from a examples type, if this last blank here was, let's say, 30 days.
Mhm.
So if such evidence is not provided in the time frame, seller may void this contract. Buyer to notify seller in writing regarding the mortgage approval or denial within 30 days of acceptance.
Mhm.
Let's say. So on day 29, if the buyer notifies the seller that the mortgage has been denied. So this contingency is still in place then on day 29,
yeah,
and their EMD then would likely be returned to the
do
buyer.
a mutual release and get it returned to the buyer.
But if the buyer on day 31 were to notify of the mortgage denial, then potentially there's a fight over.
There is an argument that the seller has to get the money back.
Okay,
So, but again, it depends a lot on what the seller does next, right?
right,
And what the seller's agent does next. If they, and the conversations, the buyer says, well, I didn't get my approval. But I think I'm going to get it in another week, and the seller says, okay, through his agent, then you've, by your actions, again, extended it.
but if in the end they never get their approval. The seller then does have a legitimate claim potentially to say, okay, yes, you aren't able to close, but your contingency is no longer in place to give you the.
Right, and he blew by his initial date without an extension, so yeah.
Another question, just to continue this. If both parties didn't mutual release the contract, can the seller put back to market, sell the house to another buyer? Because
My answer is it depends. So. I'll make it easy. If the buyer signs the mutual release and sends it to the seller,
seller didn't sign,
the seller doesn't sign.
right?
The seller may at that point put the house back on the market. Now, my advice to the seller always is, if you sell the house for the same price or more, sign the mutual release and let's be done. If you sell the house for less, then that's a fight you want to have with your lawyer and with the buyer. Because now the seller can prove, right, that they're damaged. And so that helps the seller in litigation if that's the circumstance.
But I had a case, I'm the buyer agent,
Yep,
but the seller didn't sign the mutual release.
did not sign it.
Yeah, no, I don't give back. So my buyer cannot get the money back, but I saw he just put back the lease agent put back the market. They just, deal with another person. I called the lease agent. I say, oh, you did the release. You cannot put back the market.
That's not true.
They can,
Yes, he said that's not true.
Right, they can.
They can.
They can.
because your buyer has signed a mutual release.
Right.
That.
Your buyer is telling the seller they're not going through with it.
But
There's still a fight over the.
both parties side, it's.
Right, that is dealing with just the money.
Uh-huh.
Okay, if the seller signs it, they get their money back. If the seller doesn't sign it, then the seller has some options based on whether they sell the house for the same or more or less. So if I'm the seller's lawyer,
Uh-huh.
I'm telling the seller, don't sign
Both
it,
side.
put it back on the market, let's see what happens. If you sell it for the same or more, sign a mutual release, give them their money back. If you make less on the house, then we need to think about whether we want to get in litigation with them, depending on how much less you sold it for, because that's real damage for the seller. So,
So imagine for a second,
The title company said, if you didn't release the contract, I cannot close your deal. That's true?
no,
so imagine for a second, you as the buyer's agent,
Uh-huh.
you have your buyer sign a mutual release showing that they get the EMD.
Right.
And then you send it over to the listing side. Now, the listing side could instead just then have the seller sign a different mutual release showing they get the earnest money deposit. And so now you have two different mutual releases
Mhm.
where the only difference is who's getting the earnest money deposit. So both parties are in agreement that the deal is dead. It's just a fight over then
Right,
who's
yeah,
getting the
yeah.
EMD. So whether you get that earnest money or that mutual release from the listing side, showing the seller has signed a different mutual release is kind of irrelevant. They can always just sign a different mutual release showing that they're getting the EMD. And you're still gonna end up in a small claim situation depending on the size.
So
of
the
the
only the sellers can close this deal with another buyer.
Yes, because
You sure?
your buyer.
You have to let the mutual release first, otherwise,
title company's wrong.
I don't wrong, okay,
Yep.
I remember, yeah, okay.
So now, it can get complicated, and here's the complication, okay? The seller sues the buyer for the earnest money and damages because they sold the house for less, right?
Mhm.
If the buyer, based on that lawsuit, claims that they still want the house and file what's called a lis pendens, which is a claim against the real estate based on the lawsuit, then seller can't sell the house to the second buyer and the title company will not close over the lis pendens. But that's a kind of a rare circumstance and happens very rarely. And the title company would have to have a lis pendens in order to stop the seller from selling it to the second buyer.
So which means I learned something, if I'm the seller's agent, I never let my seller sign the mutual release.
Correct. You don't
Yeah.
sell it, you don't sign it first and send it to the buyer. That's a really bad idea.
Oh,
You tell the buyer's agent, get your client to sign it, send it over to me and we'll think about it.
oh, I learned something, before I said, so you have to sign, if you don't sign, you cannot sell their house.
Yeah, no.
That's not right.
true.
Oh.
That's not right.
Oh, thank you.
You're welcome.
So yeah, do we want to move on from the financing contingency? Do we understand at least, these blanks, what they mean? What's the best practices for filling in the different numbers here? So we can then move on to inspection contingency, which is, as he had mentioned earlier, the contingency that most often comes into play when blowing up a deal. So that's where, yeah, the Ann Arbor purchase agreement and the Livingston County obviously have different language. I actually am not familiar with the Ann Arbor, but we can cover this one first. Okay, quick question. What do you guys typically put in for the number?
7 or 10.
Hmm?
7 or 10.
7, 10? Okay,
Seven.
so, yeah, so buyers should have the option for 7, 10 days from final acceptance to have the property inspected. And so then, when you have that number of days to do the inspections, in your contract, when is the deadline
So you gotta go down
going
here.
to be further down? So what's the second blank that you guys typically fill in?
Where you're notifying the sellers, and the seller will have 2 days to think, or I put 2 days for them to think about whatever you presented to them, and then you have 2 days after that.
Okay, so the 7 days is for inspections and also the deadline for notifying of dissatisfaction.
Correct.
So the first number is the crucial one to send over, yes.
Let's talk about that for just a second, because 7 to 10 days is, are we defining 7 to 10 day business days? And if we're defining business days, tell me what a business day is. Is it Monday through Saturday? Is it Monday through Friday?
Well, this doesn't give you the option, it just says days,
So I would assume
so
calendar.
it's all days,
Yeah.
it's Saturday, Sunday.
I write it
It's
as
all
Some,
day.
yeah, some do write in.
If you write, then if you write business days. The argument that you can have is, does that include Saturday or not?
No.
It never includes Sunday. The Saturday thing has become a little sketchy, I will say, because banks have started being open on Saturday. And business days has usually been in the law considered what days are banks open. And traditionally, that's been Monday through Friday. Now I've heard some lawyers argue, well, now it includes Saturday because the banks are open on Saturday. Never includes Sunday. So I think the safe thing to do is to consider it Monday through Friday. Unless you define it more. Yes,
It's not so much what I define it, it might be also somebody else interpreting the days.
well, and if you're gonna argue, if you're gonna fight about that day or a day. One of the lawyers is gonna have to wake up and say, oh, it includes Saturday. And the other lawyer is gonna say, no, it doesn't, it's Monday through Friday.
Exactly.
And that's, you go to court and a judge decides.
I would argue if you're showing homes on Sunday, now that counts as a business day.
Not if banks aren't open. I mean, that's been tradition. You know.
Yeah, I mean, that would be my case, like,
Yeah.
you do showings on Sunday,
So-
to me, you're working.
Right now, I just, before I write 7, now I just change the 7 to 10. 10 days, that's includes the weekend.
Again, most times judges will. Oh, I do have my glasses on. Most judges will go like. Look over their glasses at you and say, you're fighting about a day. One day. They don't like lawsuits like that. You know, if you're fighting over a week. Or a month, that's, you know, that's something they can wrap their heads around. But they don't. If you blow by a deadline by a day, they're really look askance at that. You know, like you, and we'll get to it, the closing date, right? The mythical closing date. And we put it, you know, whatever, the 30th of May or whatever day you put in there. And they don't close by that day. And the very next day, the seller says, I'm not going any further with you, we're done, and sells their house to somebody else. And that happens frequently. A judge is really gonna have a struggle with that, that you know, cut it off so abruptly. You've been talking to them, you've been working with them, and then something happens and you get mad and you're gonna call the purchase agreement null and void for one day. Judges really struggle with that. Some will do it, but a lot of them are, you know, not gonna let you get away with selling it to somebody else. So.
And so, yeah, so then. probably best practice to avoid uncertainty is to not do the 7 business days, but just put in whatever calendar days, so.
I mean, I would leave it like it's written unless somebody writes in business days. And then without further definition, I would strike business. If it were me and have my person initial it, but you have to evaluate. Is everything else in the offer good? Right, is the purchase price good, is, the buyer looks solid, did they give you a big EMD? All the other things, and you're gonna strike it and make it a counter because it says business days? I wouldn't do that. I would never do that.
Yeah.
There's several things wrong, right? Things you don't like, purchase price isn't right, and you're gonna make adjustments anyway, that may be a thing I would add as part of those adjustments, but if it's the only thing, I'd leave it alone.
The clarification that I want on the days, and I just make sure that I'm ahead of it regardless. But let's say Monday, the 1st, our contract is signed and we get it back at 8 o'clock at night. Does Monday the 1st count as day 1? Or does Tuesday the 2nd?
I think Monday the 1st counts as day 1.
Well,
But
Monday the 8th would be 7 days from acceptance.
Right.
But it doesn't say that on the contract. On the very last page of the contract, it doesn't say that.
What does it say?
It says day 1 starts the day after the final.
Well, if that's what the contract says, then that's what you have to go with.
And you guys have a better contract than Livingston, because we don't have
We
that.
don't have that distinction. Where does it say that?
Oh,
Next day file, see, we don't have that.
yeah, you guys are smarter than us.
So if it's defined in your contract, you have to go what your contract says. Okay, because it's further defined.
I didn't see that.
Oh, yeah, I have another question. Excuse me, Bill.
Yes.
If this contract, I write an offer, the seller didn't change anything. Except every party need to sign the bottom line. But yeah, I remember I had this experience. Nobody signed the bottom line. But the lease agent say, oh, this is not complete.
So here's the,
See, but you can change everything.
here's the thing. Bottom lining is your proof that your offer was accepted by the seller. Okay, it's your proof that the seller was notified that, or I'm sorry, that the buyer was notified that the offer was accepted without changes. That's your best proof of that fact, because you have their signature there. If they don't sign it, that's not the end of your deal. If the buyer and seller both signed it, there are no changes. Whether they sign the bottom line or not is irrelevant if you can prove that you delivered it to the buyer's or seller's agent, excuse me. Okay, so your buyer signs it, forgets the bottom line, you send it by email to the listing agent, no changes. That's a contract, that's a deal all day long, regardless of whether or not bottom lining happens. Bottom lining is just your proof that it for sure got delivered, but it's the best proof, but it's not the only proof.
Because even, let's say, as the buyer's agent, you have your client schedule the inspection. That is another way to communicate that the buyers know their offer has been accepted. They wouldn't be taking the next step as laid out in the contract if they hadn't received the seller accepted offer. And so that's,
The buyer schedules an inspection, the buyer applies for a mortgage, any of those things are also additional proof that they think they're in a deal. Doesn't have to be bottom lined necessarily, but bottom lining is great proof that they've accepted it and it's a done thing, but it's not the only proof. Yes. Go ahead.
I wanted to ask a question about 30 inspections again. Last year, it ended up working okay, but it was close, where after the inspection, my buyers went back and said, this is an issue for us. And at first, the seller wasn't going to address the issue, and then the seller said, okay, I'm gonna take care of it. But by that time, my buyer had also said, you know what, this HOA is not doing anything, and I don't wanna be part of this condo community. So I'm done. I don't wanna go further with this transaction. The seller wanted to keep the EMD. So that was a little bit of a fight for a couple of weeks until he ended up signing it, but could that have gone to court? I mean,
Sure.
how could in your experience, how do you think most judges would have responded to that?
Well, again, I mean, the judge is gonna evaluate, is your buyer being reasonable? And is there something about the HOA that makes it material to the whole transaction, right? So let's say the HOA dues are $100 a month. I can see a judge would say that's not material to the whole transaction. And if that's his only objection, he bought a house. If the HOA fees are $500 a month, the judge may have a different look at it because now it's becoming material. It may affect his ability to qualify for a mortgage and all that kind of stuff. And the judge may say he's out.
So it doesn't matter then, it sounds like, even if the buyer is trying to has signed the mutual release within the time frame and hasn't gone over that, it seems like then you're saying it doesn't really matter. That the buyer.
Well, if he's already signed the mutual release and the seller signs it without changing who gets the earnest money.
No, the seller wasn't gonna sign it.
Yeah,
The seller-
so
I-
once the buyer says I'm out and he signs the mutual release, then he's out. And this, the fight about whether it's the HOA or what it is, I wouldn't engage in. I wouldn't go to the listing agent and say, well, the real reason he didn't want to buy the house was because of the HOA. You can get in trouble by talking too much or giving the seller too much information. So if you sign it within the inspection thing and say you want out, you're out.
So you don't have to say anything at all, just do the mutual thing.
And a lot of times I get these addendums or, whatever. And they give a long, they want to tell the whole history, of what's wrong with the world since creation. Right? And something you say in that long history is going to piss somebody off. That's a legal term of art, by the way, for those listening. And so less is more, right? If you're gonna send a mutual release, I would hesitate, unless it's if it's a major thing, right?
But the
Septic-
seller's agent wants to know because the seller wants to know.
Sorry. Not at liberty to say, we just want out and we're allowed to get out. Right?
Well, you do that, so once you notify the seller in writing of the repairs that you want. It says if seller is notified, seller will have X days to notify buyer in writing of the willingness to correct.
Right,
So if the seller did that within however many days of you notifying them of the repairs, then they can't now just say, buyer can't now just say I'm out.
nope.
The seller has at least so many
You
days.
have to do what this says down here, right? So the first option in this contract is buyer may declare this contract null and void or notify seller in writing during the time frame for the inspections of the defects identified in the inspection. So buyer gets the inspection report back and says, I'm out. For whatever reason. He can be out because the HOA fees are too much or what they're doing drives him crazy, whatever. If he says I'm out, he's out. He gets the first choice. Right, so this is a very buyer friendly contract. But if you say I'm out, you don't have to give them a reason, you just say I'm out. Right, I sign a mutual release and send it. Now they're gonna pump you for information and it's up to your buyer whether he wants to give them any information or not. But all the time I see that we give the seller information that the seller then uses to say you're being unreasonable. And I'm gonna sue you because you're unreasonable because your inspection didn't show you anything that that says the house is damaged. You know, there's a, what do you call those plugs? GF5?
GFC.
Yeah, there's one GFI in the whole house that doesn't work and you're gonna declare the purchase agreement null and void. That will cause the seller to fight back. Now, I don't think you'll win with this language because it gives the buyer the first option. But you shouldn't give him ammo, right?
But now my reading of this paragraph would be either you can, declare null and void, or if you did find a defect, let's say the roof was bad, that's what the inspection found. You should send a notification that you're dissatisfied because of the roof. Now, if you do that, the seller has the option to say, okay, we'll credit you 15,000, or okay, we'll hire somebody to replace the roof. But even if they do that, your buyer then still has the option to accept that offer from the seller on the remedy. If, when you discover that there's a bad roof, if what you send over in writing to the other side is seller to replace the roof, then you've made the offer and the sellers just have to say, okay, and now your buyer's bound. If instead you say you're dissatisfied because of the roof, let them make the offer and your buyer still has an out. You know, even if it's because of the HOA, they changed their mind, as long as you didn't make an offer that then the sellers have accepted, but you've just told them why you're dissatisfied, you can stretch it out with those extra days.
Right, so you give them a notice, there's something wrong, let's use the roof. Right, you give them notice, then the seller has an option. Right? Seller has, they can collect it. They can credit the buyer a sum of money at closing or reduce the purchase price. Now, and they make that offer back to you, then you have the right to say yay or nay.
So in that instance, though, the roof is bad, it's gonna, the seller is going to replace it. They have come back and said, we'll replace it before closing. And then you have 2 days to, accept or deny, but can you deny that? If
Sure
they,
can.
you gave that reason and they said, okay, we'll fix it.
Sure can.
In
Gives
this,
you the option, right?
this contract.
Yeah,
It's not just a contract, some contracts are like that, but this is
If you look
the,
at the Livingston County, it's.
ours is not. at all
But
like that.
if the seller is very strict, he said, oh, my price already in fact the roof. I don't want to give you anything.
Then
But the company says, oh, okay, that's good, that's mutual release. But the seller is very bad, he said, no, I'm not mutual, you waste my time. So what can the buyer do?
in that instance, it's broker to broker. The one broker has to contact the other broker, be like, listen, your seller's clearly being a jerk. You know, get the agent to get the client to do the right thing.
And sometimes that conversation goes nowhere, broker to broker, right? And you just have to wait.
Yeah.
And
And
if,
you can't prevent
right,
jerks from being jerks.
and
Our job as
and what-
agents is to get our clients to not.
my decision then becomes, right? Lansing says you hold it till you either get a mutual release or something that directs you how, a court order that tells you how to release the earnest money. So that's gonna be my initial reaction. I'm gonna say, nope, sits on our escrow account until we get one of those two things, a court order or both people sign the mutual release. Seller being a jerk is irrelevant. Then I wait, right? To see if the buyer is going, if the buyer or seller are gonna do anything. You know, is somebody gonna start a lawsuit over the earnest money? And I wait. And I may wait 6 weeks, 8 weeks. And if 8 weeks is kind of my tipping point, if nothing's happened in 8 weeks about the earnest money. And you can show me that the seller's moved on, maybe they've sold the house, maybe they haven't, but they've put it back on the market. I may, depending on how good your story is, give you an addendum that we have created that says we've tried to get the seller to sign a mutual release. He won't. The buyer's gonna hold us harmless for giving him his money back If everybody signs that, then I've been known to release the EMD. But I'm not gonna do it in 2 or 3 days. You know, we're talking 6, 8 weeks down the road when no one's filed a lawsuit.
So if someone does file a lawsuit, typically, how long does it take before you appear in front of a judge?
6 months.
6 months.
Oh,
And
but
none of these EMD list pendants will stop the sale of that property, right? You
No.
can't put a list pendants for over EMDs.
No, because list pendencies are only for things that affect title to the property, and if you're just. The lawsuit's clearly just about who gets that money, then yeah, it can be sold.
but you say it's good news. You say that after 6 weeks, if nobody claimed the EMD, the broker should return the EMD.
I'm not saying the broker should. Hear me clearly, okay? What Lansing says is we should never release the earnest money unless we have a court order or a mutual release, okay? That's what we should do,
Oh, okay.
okay? I've been around the block once or twice, a few miles on my treads, right? I know if nobody's done anything or 6 to 8 weeks, that the likelihood of them doing something, filing a lawsuit is pretty tiny. So Mr. DeCruz has given me the authority, because I've been around the block once or twice, to release them if I think that the likelihood of a lawsuit is not very good. So I'm really not doing what the broker should do. I'm doing, based on my experience, what I think I should do. Okay, so I'm pushing the envelope. And Mr. DeCruz doesn't like it. I push this particular envelope. He would prefer that we just left it in escrow until they deal with their problem. But I get it, that you guys got a buyer that you want to buy another house for or whatever. So if you tell me a really good story about why the mutual release isn't signed, you may get access to that addendum. And I'm the only one that has it on his computer. So you gotta come to me to get it.
Okay.
So how many lawsuits over EMDs does Remax Platinum deal with?
Not many. Not many. Because usually, we're able to negotiate our way out of it, talk our way out of it. You know, the real answer most of the time is you split it. You know, and make both parties go to their separate corners and you split it 50-50 and call it a day. It's not worth the fight. When it's worth the fight is $10,000 seems to be the tipping point. Over 10, it's worth it to fight about because you can get a lawyer for 5. So you're making money. Under 10, it's really questionable whether you're gonna, you know, you're gonna spend more than you're gonna get in a lawsuit. So I can usually make that pitch and cooler heads prevail. It takes some time sometimes, but we don't go to court very often.
Let's compare now the Livingston County inspection contingency, kind of quickly. Because this is recently revised by the LCAR board. Purchaser shall have the option to inspect at the purchaser's inspection. Contingency expires on blank days, so 7, 8, 10, whatever, you put it in there. In the event purchaser neither expressly waives contingency, contingencies shall be deemed waived. The inspections can include anything they want to inspect. If purchaser is not satisfied with the results for any reason during the inspection period, so again, they don't have, they could be HOA, it could be no stated, could be that their favorite baseball team just lost the World Series.
I don't like this paintball.
Yeah, they changed it.
Dog barks too much next door.
Yes. So they have 2 options. They can declare it null and void, or in ours, they have to propose an amendment. So it's us being on the buy side having to send the offer over, a counter offer over, that gives the seller the ability to accept or reject. So it's a little bit different than what the Arbor purchase agreement showed. So that makes it a little bit clearer then in that, you know, yeah, it's the buyers, it's their responsibility to say what would satisfy them based, you know, to satisfy that inspection contingency. And then it's in the seller's court to decide Do they accept that? Do they propose, if they propose a counter offer, then it's back on the buyers, and the buyers could reject and get their E&D. But if they sent that addendum over, and the seller is accepted, the buyers don't have the ability at that point to cancel things.
Oh, I think this is better for the buyer. Your agreement is good for the buyer. Because the buyer can say, okay,
So here,
instead
so
we can void.
this purchase agreement took a year-ish to craft. There were 2 lawyers on the committee, a bunch of realtors who sell a bunch of real estate. And the consensus was that if a buyer wants out of a contract over the inspection, he's gonna get out. One way or the other, he's gonna figure out a way to get out. So why not make it easy for him? And so that's, I wasn't personally, I like better the options like Ann Arbor has, my preference. But the committee decided this is where they're gonna go, and this is very favorable, you are correct, to buyers.
The on or before, expiration on or before, how did something expire before a deadline without it being waived?
It's, I don't know, I didn't write it. I agree with you, it's sketchy language and it shouldn't say on or before. It should just say on or, yeah.
Yeah, give a specific date of when.
Could
it
a seller
expires.
argue that it?
It
Well,
could be
expired before
before.
You have
Not expired, but-
you have to remember, my favorite rule of all rules is that any idiot with $82 can sue you for anything at any time. So someone certainly could make an argument about that, and I've seen contracts come back that have had attorney review where they've struck that on or before language. You know, so it just depends. I mean, is that a hill that you know, again, you get before a judge and that's the hill you're gonna die on, you're gonna die. If that's your only thing that you're bitching about, judge is gonna, again, look over his glasses at you and go, really? So. Right, any other questions about that?
So yeah, so we covered the financing contingency, we've covered inspection contingency.
Here's a missed one.
Title.
David says this purchase agreement upon saying purchase shall have 7 calendar days. Watch this, this is title insurance. We don't pay very close attention to this. Purchaser shall have 7 calendar days to provide seller with written notice of any objections. Seller will then have 30 days after receiving written notice to remedy that defect. Have you ever had a problem with title? Did you ever use this paragraph? Very few people do, but it's there.
So question, so the seller is going to apply for title insurance.
Okay.
And the seller, the listing agent is going to receive the title commitment.
Yep.
Is it the listing agent's responsibility to send that over to the buyer side?
I would say yes.
Okay, so if the listing agent doesn't send the commitment over to the buyer side, then the upon receipt of the commitment never occurred on the buy side.
And so.
So you as the seller, you should, or the listing agent should be sending your title commitments over to the buyer's agent.
And if I'm the buyer and I've never received it.
Yeah.
You could argue that this goes on forever until I do.
What does it say in Ann Arbor one?
Yeah, and I would have that, too. Yeah. You. Take the picture.
I don't know your contract well enough
Yeah,
to,
yeah, the second page, I saw it.
page 2.
Yeah, attorney approval.
We're looking for title insurance.
Right here. No, this is
Not a.
that's not it.
That's good. I have a question about that title insurance. So they have 2 choices, with or
Hold
without.
on one second, let's deal
Yeah,
with one
let's-
question at a time.
Find the,
Yeah,
does anybody know where?
yes, the second attorney approved, the second page.
Yeah, that's got nothing to do with the title.
Yeah.
No.
Like,
Wait, really?
Where the attorney approved, there is a typo.
Oh,
Well, that's page 4, attorney.
and you're saying that on the.
Yeah,
attorney
attorney, yeah.
approval-
But number
Oh, sorry, I just go like this.
Yeah, but that's-
third
Yeah.
line.
Yeah.
Approval,
Approval of current
Yeah.
commitment.
owner's policy.
Why, so that is the attorney approval.
So what if,
Yes.
Good God.
Attorney, you have to receive the title year first.
what if nobody wants attorney approval?
You see this, the third line, approve current.
No, I see where you're talking from.
Buyer doesn't want to hire an attorney.
This is way different than the Livingston County one. It doesn't provide for a remedy,
Yeah,
really. You know, the owner's policy and associated with the by waiver of this contingency will be subject to any, this is a great word, substantive revisions to the title company. That's lawsuit language,
yeah, because
right?
it's
The
vague.
attorney can say it's a sub-
Buyer agent, I already checked the third.
Check, so would buyers get their own attorneys to review the title commitment?
What if they don't?
Doesn't matter, because I
It
checked,
does matter,
doesn't matter,
for sure. What if?
but I already checked the third box, the seller agent already sent me the title commitment. I said, buyer want to review the title.
What if your buyer doesn't hire a lawyer? Who's gonna review the title commitment?
The buyer can review.
It says by buyer's attorney. Like, it doesn't say that the purchaser is reviewing it, it's being reviewed by the buyer's attorney,
Yep,
by buyer's attorney. It doesn't say anything about it being subject to the buyer's own
and
satisfaction.
unfortunately, it goes on, you know, the fourth box talks about. Approval of condo docs and stuff,
Yeah.
but
And
it's
again,
by the buyer's attorney. It's not by the buyer.
It says,
Oh.
but by buyer or buyer.
yeah, that's,
So,
but that's receipt,
so your question is,
approval by buyer's attorney,
Mhm.
I guess.
so your question, if I check the box, that's,
You have to hiring an attorney for that to be a fact. If the clients aren't hiring an attorney,
it's not, I want to know what's going on.
Hmm?
It's nothing, if the buyer didn't hire an attorney, but the box is checked,
yeah,
so that means.
it does not serve your buyer any good if they are not hiring an attorney.
Oh, I didn't know that.
Because all of this is about giving the buyers the option to have attorneys review things for them. But if they're not doing that, it doesn't give them to act as their own attorney, you know, and do their own review and say
But-
satisfied or not.
The seller doesn't know the attorney reviewed or buyer reviewed. You don't
Seller doesn't know.
Yeah, I didn't tell my buyer doesn't have attorney, who the, of course, she had, the buyer had. But the seller also checked the first box, he said the seller's attorney approved.
If you don't, I mean, again, it's, I don't know what you do in practice, but if you're not gonna hire an attorney, you should not be checking those boxes. Because it doesn't help your buyer at all, and if it went to court.
Mhm.
Then it's gonna come out that it wasn't your buyer's attorney that objected, it was your buyer. And then a judge is gonna rule against you because you violated the contract. Because it's your buyer's attorney who is supposed to do the review.
But I always saw if I have the buyer agent, the seller already checked the first box. You said the seller,
So if the seller jumped off a bridge, are you gonna follow him and jump right off too?
but I'm the buyer agent, I don't know seller has the attorney or not.
So, yeah, but.
We don't have.
But you know whether your buyer has an attorney or not. And if your buyer doesn't, you shouldn't check those boxes.
Oh, the buyer said that she has, if she said she has.
Well, if she has one, then yeah, go ahead, check them all if you want.
So you think I should have checked the box?
If your buyer definitely has an attorney, go ahead and check them. If your buyer has no attorney and doesn't intend to hire one because it costs too much, which is normally the case, don't check them.
Don't check it. If you check, what's the problem with you?
If there's something wrong and it causes a lawsuit, and you get to court and your buyer's the one that pointed it out, not the buyer's attorney, you're done, you're gonna lose your
Well, the
lawsuit.
title commitment survey. No, that's in yours.
Yeah.
Can we add a statement that buyer,
Yes,
under other, on the first page?
Yes,
yes,
Buyer is to approve the title commitment.
yes, you may,
yes.
you certainly can.
Did you hear that, CJ?
Oh,
You can add that.
change it to buyer.
Yeah, just add it in your contingencies.
But
On the first page.
so I'm not finding anything in the Arbor contract about there needing to be a marketable title, that there's a contingency on the seller actually being able to convey title.
Are you sure?
Yeah, I can't find it
It's
anywhere.
in the listing contract.
Well, that's between you and the seller, not between,
Oh, darn.
I do, would, like, maybe I'm in, I didn't,
Title insurance.
yeah, it's not there.
well, they will provide an Alta owner's policy.
Yeah. Without, which box you should check.
Without.
Oh, no.
You should check without.
But without, if the single house, once I checked the without, they charge my buyer a lot survey fee. It's all, you check the without,
Well, again,
you have,
if the house
Uh-huh.
is a lot and a sub
Uh-huh.
or a site condominium, then it's likely that there will be no charge for a survey by the title company. But if it's a big piece of vacant land out in Scioto Township, then the title company is gonna require a survey to give you without exceptions.
right,
So that's you have to decide at the outset. What piece of property I got and whether or not my buyer is gonna be willing to pay its survey to get without exception.
but actually, that house is a subdivision,
Subdivisions, you generally don't need a survey.
but the title goes still charged by buyer the survey fee. My buyer, so why you charge this fee? Because I need the without, the title company, so you check the without box. So I'm the bad person, it's all.
All I can tell you is. Can't speak for all title companies, but I can tell you that if it's select. And you check without, and it's a lot in a sub or a site condominium. We're not gonna require a survey in most cases, unless there's something else out in the air that tells us there's some sort of problem. But just normally, we're not gonna charge extra for that.
All right, so Bill, I have a question.
Yes,
So in the Livingston County one, it talks about, to remedy the claim defects in a title.
Yep.
You know, when you get a title commitment, what are some possible defects that would be found in the title commitment that not having any language about it in the Ann Arbor contract could put then the buyers on the hook of just having to accept?
well, one thing that attorneys sometimes object to is the fact that you have to probate an estate. Because you can't transfer clear title without probating the estate and getting a court order. Some sellers will object to the time that's going to take. It may identify, especially out in the, what I'll call the hinterlands, so Scioto Township, places with lots of vacant land. There may be oil and gas leases, there may be stuff like that that a seller could object to and want those released. That's another thing that would delay closing. So those are kind of the things I see the most.
Okay, and so in Livingston County, yes, our buyers, when they receive the title commitment, they can object to certain things and put it on the seller to remedy. And if they don't remedy, that's a contingency, can cause the deal to fall through, buyers get to redeem back. It does not appear, at least from my glance through the Ann Arbor contract, that exists for the buyers.
Yeah, so Ann Arbor's relying on this, that you'll provide a standard Alta owner's policy of title insurance. The Ann Arbor one doesn't talk about commitment at all, dealing with saying, so as long as you can fight through the commitment issues, you know, and title companies do a commitment review and say, you gotta fix this, this, and this. and you can get through that and they can provide an Alta owners policy, you're good in the Ann Arbor one. So there's no buyer objecting and getting out. That's different than Livingston.
So that's an important distinction.
But you see the, if the use by, an Arbor contract, if that buyer doesn't have a attorney, so buyer will not have a title commitment.
They won't have, it won't be a contingency that they get to review and accept the title company. It's just, there will be a title commitment, but they don't get to object to it and have that be a reason to cancel the deal. Let's say,
I'm a lawyer.
right, yes, unless they had an attorney.
She just think I can revise the contract.
You can always write an addendum, you can exceed the language that's from the Livingston County.
Can just cross the attorney approval, sheet to buyer.
Don't have to do anything with it. Don't even address it, but put in your additional conditions.
Yeah.
Wherever they are, that buyer reserves the right to approve the title commitment.
Oh, okay.
Yeah,
It does say too, any special exceptions will be subject to buyer's approval. Is that, that is 3.6, title insurance 26.
so I have an old,
We have
No, it's
a full version.
a special exception. I'm not, that could be oil and gas leases, that could be probate court, that could be things like that. The buyer could hang his hat on,
Or easement.
or easements or things like that. So that's where they would, subject to buyer's approval, but they're, most times what's gonna happen is you're gonna work through those issues from the commitment. Doesn't really, give you any timeframes about, how long will we fight about it or, whatever. And Livingston, you have buyer gives you notice and then the seller has 30 days to fix it. This really doesn't address the timing, but it does give you the right to approve it. So. Most, I'm gonna say 90% of buyers, the commitment goes whoosh right over their head. Probably 50% of real estate agents, the commitment goes whoosh.
and that's why we've had
I don't-
classes where like Andrew from Select has taught how to read a title commitment. Because I mean, it is a skill that we as agents need to be well versed in. Because yes, just sending it out to our clients,
Yeah,
not necessarily helpful.
Right.
All right, so let's move, we've covered financing, inspections, title. Can we do a home sale contingency? Because that's obviously one that is not part of every transaction, but when it is, that can cause a lot of headaches if things are not clearly defined up front. So I know in our Livingston County purchase agreement on the final page here, we have these options of contingency on sale and closing of purchaser's property or contingent on closing, which are two different contingencies. One is the home still doesn't even have a purchase agreement on it. The other one is, okay, they've got an accepted offer, but they need to close in order to have the funds. So let's pretend though that, yeah, your buyer, their house isn't even listed yet. They're gonna be listing it if their offer gets accepted.
So that's the first one.
Yeah, the sale, now
This is not, if you get an offer from a Livingston County agent, this is not the whole thing. You just check this box and go on about your life. You gotta see this.
Yes.
This is the addition that you have to add.
because yeah, we have two addenda then that if we check this box, I know I'm going to be including two additional documents. I'm gonna be including our specific contingencies addendum, but then on the second page at the bottom, contingent on sale of purchaser's property. And so I'm gonna use this along in conjunction with the additional attached addendum, which is this one, to clearly identify all the details that are important. So we let an offer, it's contingent on the buyer's house at 123 Main Street having to be listed and sold. So in this original, we're checking the box here, saying contingent on sale and closing. In Ann Arbor, where would yours be for that? Do you guys have that? It's at
Bottom of page 4,
bottom of page 4, what page am I on? Page 5.
right there.
Okay. So,
So you have to get a signed purchase agreement within a certain number of days. He has to get a non-contingent signed sales contract within a certain number of days, and then closing within a certain number of days.
right, so typically you guys would be checking the first box. You know, this contract is contingent upon successful completion of the following regarding the property at 123 Main Street.
Usually how
And
many
then-
days we should put the first one?
There's no, I mean, that's, you gotta kind of, I don't know what your market is in Ann Arbor, I don't know anything about it, so it's, you know, it's something that, what's reasonable to sell a house that's not listed?
Right,
You know, is it 60 days, is it?
so yeah, you check the box, you put in 123 Main Street, then you're choosing between these two options, because you shouldn't really be doing both, probably. You probably want a signed sales contract that isn't another contingent offer. Within, give yourself 2 weeks to get the house under contract, so listed and accepted in
So
contract.
if you sign the second one, non-contingent sales agreement, that's a cash offer, no inspection contingency, nothing. So, that's tough to make the buyer do that.
Yeah.
If you're a seller, you may want that, but that's a tough,
So as a buyer agent, should check the first one or say?
I would check this.
Yeah.
And this and that,
Yeah,
not the middle one.
Oh, not the, okay.
The intention of the middle one was for it to be non-contingent on the sale of another home, but you're right, it's no contingency.
No contingencies at all, no inspection,
Oh, which is-
financing, no.
The second one is the.
That's true.
It's tough.
You have to buy or doesn't care you're selling your house or not. That's the second one.
The second one, you're telling this buyer that he has to go out, list his house, sell his house. Let's say you put 2 weeks up here, 14 days. He's got to list his house, sell his house, and it has to be cash, no contingencies.
the offer that he accepts on 123 Main Street
You're
cannot have annual contingencies, like an inspection contingency or any of that. Which may not have been the intent, but that is the plain reading of that at least. But then, yeah, you're also checking the box, closing on the sale of the above property within 45 days. Because, yeah, the dates are all about this contract. So you're looking at, okay, if you get it 123 Main Street pending within 2 weeks, and then 30 days for closing that, you're looking at about 45 from the moment of this offer being accepted.
You also, buyer's taking a risk because, if buyer's in default because he can't get a mortgage because he didn't sell the house, he forfeits the earnest money. So that's, you know, that's tough.
Oh, wow, so,
But it
yes,
says after buyer has waived full contingencies.
so after the 14, okay, so let's say you give an offer on 123 Main Street that they accept. And so that 14 days have gone by, they've accepted, but if that deal falls through, they've already waived, this contingency has come and gone. And so at that point then, yeah, okay, if that sale of 123 Main Street falls through, they're potentially at risk then of their EMD here being at risk because they're no longer, because of the failure to sell 123 Main Street, if these dates have come and gone. If the deal on 123 Main Street fell through before the 14 days are up, you then can still try to get another buyer. And if you don't get another buyer, then you've got to say, okay, on day 14, sorry, we weren't able to perform. And so we need to get our EMD back and
So I see a lot to cause them to default is that they mess around with the closing on a deal that's not really gonna close, you know? And so they, you know, they say, oh yeah, it'll close, and so we are waiving all our contingencies on this contract. Right, and then their deal on 123 Main Street never does close. So they then forfeit the EMD, which is, you know, contingent sales are, I guess, a necessary evil, but I always think of them as evil. I would much prefer that you didn't do them, or we, somewhere in our lexicon of documents in our system, we have a document that we call the drop dead clause, which basically says you keep the house on the market, it's contingent. You keep the house on the market, and if the seller gets another offer that he likes better, buyer's out.
That's this right
That's
here.
the one's out.
That's the next number.
Yeah,
That's 36 for our contract.
Oh, okay. Go ahead. Gotta get closer to the computer.
So what do you call that in Livingston County? We're here in our system, it used to be ALTC. You know, you'd be scrolling for listings, and if you saw one that was ALTC, I would get excited because I'd say, oh, I can still show this property.
So in the it's CCS, contingent to continue to show, that typically communicates that there is a accepted offer that is contingent on the buyer's house selling. And so you, as the agent with another buyer, you can sweep in, submit an offer, and it would then trigger, if they're using an addenda, it would trigger this. So contingent on sale of purchaser's property addenda. Sales, contingent on the satisfactory sale and closing of 123 Main Street. So this is saying not just getting the offer accepted on Main Street, but also closing Main Street. Until you have closed Main Street, the seller shall have the ability to still show the house. And if they get an offer, another offer that they want to accept, then they're gonna notify you as the buyer's agent, who's trying to sell 123 Main Street, that they've got another offer, and now you shall have typically 48 or 72 hours is what's going in here. 2 days.
notice it's not days.
Right.
It's hours, you gotta jump on it.
Yes, you shall have, 48 hours, 72 hours to accept, accept that, okay, your buyers aren't going to be able to remove the home sale contingency of 123 Main Street, and therefore then they get their EMD back, but they're walking away from the transaction, or you're removing the contingency on 123 Main Street with either the following. A purchase agreement, so this is written in all the leverage goes to the seller, because the seller shall have the sole right to accept proof that you have gotten an accepted offer on 123 Main Street. If they look at that contract and like, we don't like that there's a appraisal contingency in that contract, we're not satisfied, then we still want to go with the other offer, your buyers don't have the ability. Or they must provide proof that they can do financing even if they don't sell 123 Main Street, which again, the sellers can say, even though we got this letter from your lender saying you can actually move forward with purchasing this house, we're not accepting that letter from your lender. That would be a little bit more, litigious, but I mean, it's just one of those that keep in mind, that's,
It's basically drop dead. Perform or you're out.
yeah,
And the seller gets to decide whether or not the proof that you're giving them is acceptable. So most people who sign this feel like they have a pretty hot house. So they're not willing to take it out of the, off the market really. And so they get this signed. And typically, I would say I don't know what your experience is, Jordan, but most of the time, I think this kicks buyer number one out in favor of buyer number two.
yeah, if you get, but I mean, most listing agents, at least I'm not going to be accepting a contingent offer and then be a total jerk to the other side. I'm going to know full well that, yeah, you know, if it's been only like 3 days, you know, and we've got another offer, something where, yeah, the buyer number one still hasn't even listed their property and all that. It's like, okay, you guys need to recognize that we got this better offer. You're not gonna be able to satisfy this. But if the buyer or the buyer number one has actually listed 123 Main Street, and they have sent us a purchase agreement showing that they are close to closing, even if we get another offer that is wonderful, it would be devastating to actually kick the buyer number one out of the contract, because they've sold 123 Main Street, and they're not gonna be homeless because I'm a jerk, you know, in order to go with the offer number two. My conscience wouldn't allow me to do that. But there's agents out there. There's agents out there who are ruthless, or sellers out there, maybe your seller, is demanding you have to do what your seller says.
I'm gonna get more money.
Right. Yeah, they're gonna get $10,000 more.
I'm also amazed, however, of how many people do a contingency when they have the ability to do number two here.
I have clients right now that are insisting on home sale
They've
contingency
got
when they don't have
money.
to, and it's killing them.
Either they have cash in the bank, or, they have the ability to carry both houses, they just don't want to. Right? And so, it amazes me all the time that they sign this knowing full well that they can carry both houses. It's inconvenient, they don't really want to, but they have the ability to, so.
I have a question for you, because this was posed to me from an agent last night, coincidentally, and I told her then that I was going to use this in our class. So she was writing an offer with a home sale contingency of 123 Main Street, which is not written or not listed yet. So in her offer, in the additional area, she wrote, purchaser's home located at 123 Main Street will be listed within 7 calendar days from acceptance. Purchaser shall notify seller in writing once 123 Main Street is under contract. Once the contingency changes from contingency on the sale to contingency on the closing, seller will only be able to accept offers for backup, effectively rendering that, here where they can't kick out
Right.
buyer number one.
You can do that.
So that would be language then, if you're using this in order to prevent your buyers from becoming homeless because they've sold 123 Main Street, but then the sellers on this house get another backup.
I guess the only thing I would add to that is that the seller has to be satisfied with the purchase agreement on 123 Main Street, so should give the seller the option to look at it and say whether or not it looks like it, because.
But the listing agent would want to counter with that.
Yeah,
The listing agent would want their sellers to accept that as written.
right.
But for the buyer's agent to write it that way, let the listing agent do their job of
Right.
protecting.
Yeah, for
Yeah.
sure.
This is so helpful, I really appreciate it.
This is great.
Yeah,
On the Ann Arbor contract, line 36.
36.
Where it gives us the limited time, the actual limited time clause,
yes.
I leave that blank. When I've done this before for a buyer. Because I'm hoping the seller's agent forgets this.
Mhm.
And the last time I did this, she did.
She did or didn't?
She did forget. She left it totally blank. I was like, oh, okay. Fine, this is good. But it worked out really well for my buyers. I listed their home, we got under contract really quickly, but I was really amazed that they left this blank.
So this is similar to like the 48-hour,
Right.
rather than 2-day, but here you've given yourself infinite days.
Yeah, you have as much time as you need if you don't fill a number in.
So this limited time clause is for the buyer,
Yeah,
for the buyer.
Well, the buyer acknowledges that the property is not being taken off the market. If the backup offer is accepted, then the buyer will have a blank number of days from receipt of seller's written notification, blah, blah, contingent, So if you leave this blank, right, you have infinite number of days to sell the house, really, to remove the contingency. So if you get away with leaving it blank, you've outsmarted the listing agent.
Smarter than this thing. Yeah, okay. Maybe, but if you said submit the seller, this agent will fill up the. blank.
Yeah, I mean, in her experience, they typically find it, but in the case that she just talked about, they didn't.
This.
And it benefited her.
Okay.
So, you have an obligation, a fiduciary obligation to represent your buyer to the best of your ability. And if you can slide that through blank,
Good for the buyer.
you've done your job, you didn't do the listing agent's job,
Good job.
okay?
Are there any other contingencies we wanna go over, from like the specific contingencies? And obviously, it's been a long class, but I mean, it's a lot of content.
I have one last question.
Sure.
If your clients agreed to be a backup offer,
Mhm.
and then they are able to get another contract accepted offer that they're on a different house. Is it necessary to go back to that first offer and say, please remove us from the backup?
Absolutely.
Okay.
Yep,
Rescind your offer.
yeah,
Yeah.
either rescind it or get a mutual release of it, because the only way to kill something is to put a stake in the heart of it, and the mutual release is that. So I would mutual release the backup.
Even if it wasn't signed by the seller?
Well, then it's not a deal.
Yeah, so if you just have a building.
It's not a legitimate backup offer if it's not signed, so.
Yeah, I have a question about that.
Then, you said rescind, right? Yeah, I would send something, email, something in writing that says I'm rescinding my backup offer. That
Yeah.
should be good enough.
If I submit an offer, the lease agent say, oh, you also only can be a backup. The lease will check the backup. As I'm the buyer agent, can I look for another house? If
That's just what she was talking
Yeah.
about. You look for another house,
I
find one you like, rescind the backup offer or get a mutual release on it. And then-
need mutually. That's my question. So I remember this vision, oh, you don't need to do anything. If the first offer fall apart, I will call you.
So who do you represent? The listing agent?
I'm
or
a
buyer?
buyer agent,
So you represent your buyer.
yeah.
So you're gonna get a mutual release, because it benefits your buyer. And you don't care what the listing agent says.
So the lease agent said, your backup offer, you don't need mutual release.
Well, the
We don't,
listing agent's wrong.
oh,
Now, if it wasn't signed by the seller, which was her observation, if it wasn't signed, it's just signed by your purchaser and sitting there and never been signed by the seller, then do a rescission of that offer. Put in writing, via email or whatever, that your buyer's hereby rescinding their backup offer, dated blah, blah, blah.
Two different types of backup offers. There's the backup offer where you've submitted it and the sellers have signed it as a backup offer. There's the backup offer that colloquially, I think, is more common, which is you sent over an offer and they verbally, okay, if first deal falls through, we'll go with you guys, and the seller will sign it then, if the first deal falls through. The one with the true backup offer where the seller has signed it, you need a mutual release.
we did.
The other one, you just need to notify them that you're rescinding the offer
Because it was never signed.
because the seller never actually signed it.
Okay?
Yeah, thank you.
You're welcome. All right, we're good?
Yes.
Yeah, we have a lot of.
Appreciate it.
Thank you.